Good afternoon. I haven't had the opportunity to meet Mr. Spellman before, and had I known he was going to talk about numbers, I'd have made up a slide. And the first slide would be 37,000. And that is the number of children who have been poisoned by lead-based paint in their homes in Rhode Island since the early 1990s. Second number that I would have put up there, I think, is the most important, and it's the number 6. 6 is the number of jurors in Rhode Island who unanimously rejected every single argument that you just heard. Every number crunching, number changing representation that was made to you was put before a jury of 6 Rhode Islanders over 4.5 months. They came back and they unanimously rejected it. And they rejected it because they found that the fact that there is lead-based paint in children's homes in Rhode Island constitutes a public nuisance. When I was asked to come here today, I was asked to talk about public nuisance. And that's what I'm going to do. I'm not going to talk about contingency fee issues and the American jurisprudence system and whether it makes sense and whether it doesn't make sense. I think that's a debate for another day. And I think what's the important thing here is what is public nuisance and why does public nuisance fit in these lead cases? Public nuisance is one of the oldest legal claims that exist in this country. And in fact, some have dated it back to the time of the Magna Carta. It's certainly been dated back to England in the 1500s and 1600s. And here in the United States, it's been here since the late 1600s and early 1700s. And traditionally, public nuisance has been used for a wide variety of claims. It's been used for everything from an obstruction in the public road, disturbances in places, and things like that. And in the last 25 to 30 years, public nuisance has been used increasingly in environmental cases. Think things like the Exxon Valdez, Love Canal in New York, where you have this massive environmental pollution that needs to be cleaned up before it harms people. What you see up here is the definition of public nuisance under the restatement, and it's an unreasonable interference with the health, safety, or welfare of the general public. Now, that's kind of a broad definition, and it sounds amorphous. But as you get into public nuisance law, what becomes clear is that public nuisance is not a massive doctrine that could encompass and engulf an entire body of product liability, but it's actually a very, very narrowly tailored doctrine that only works in very discrete kind of cases. And in the last 8 years, it's been used in the environmental context of the lead poisoning cases. Now, to understand why it fits, you need to understand what lead poisoning is. Lead poisoning has been called the most common environmental health risk to children in the United States today. And you heard reference to Mattel and to China, and that's where the problem is, but any well-respected public health authority tells you it's not Thomas the Tank Engine from China that is poisoning children in the United States. It is lead-based paint that is in their own homes that is the most common and overwhelming source of lead poisoning. That's not a litigation position. That's a position that's been taken by the United States government, by the Environmental Protection Agency, by the Centers for Disease Control, by the American Academy of Pediatrics. Everywhere you look, everybody will tell you that that is where the problem is for children today. It's not from Mattel. It's not from China. Children under 6 become lead poisoned when lead-based paint in their home can chip or flake or deteriorate, and they ingest it. And it goes into their system, and it actually gets into their brain, and it interferes with the way their brain develops, with the way their brain grows, with how their central nervous system functions. And at very high levels, it can cause seizures, it can cause coma, and it can cause death for children. Now, since the early 1990s, lead poisoning has received a lot of attention from the public health community. And it's really unique as a medical and scientific issue because it's a consensus. Outside of litigation, There's a consensus in the medical community that lead poisoning is very bad for children and must be prevented. Since the 1990s, what the public health authorities have attempted to do is go from what's called secondary prevention, where you treat children who have been lead poisoned, to primary prevention, where you prevent children from getting lead poisoned in the first place. And the reason for that is once a child is lead poisoned, the effects are permanent and will continue throughout their life. So the best idea is to prevent that poisoning in the first place. And in 1999, it was the Rhode Island Attorney General, who is now United States Senator Sheldon Whitehouse, who recognized the problem of lead poisoning in Rhode Island and the necessity for shifting for this secondary prevention where we treat children to primary prevention where we prevent poisonings. And the primary suit, or the primary claim, was a public nuisance claim. And since that case has been filed, and other cases have been filed in Milwaukee, where the Court of Appeals of Wisconsin upheld public nuisance in lead poisoning cases, in California cities and counties where the California Intermediate Court also upheld public nuisance cases, what has come out of it is this distinction between a product liability claim and a public nuisance claim. And you see this defense that, hey, we're product manufacturers. You can only sue us in product liability. We don't belong in public nuisance cases. There's some very critical differences between public nuisance cases and critical differences that really make a difference to how these cases are tried and why public nuisance is so limited. The first is, under a public nuisance case, it's a government entity that brings a claim. It's your representatives, it's the state, it's your cities, it's your counties. It's not brought by a particularly injured individual like the product liability claim is. Second key distinction is between the remedies that are available. Under public nuisance is this amazing doctrine where the state can come to court and seek to render harmless a dangerous condition. You don't have to wait until 50,000 more children or 5,000 or even 500 more children are poisoned. What you have to do is you have to come and you have to show there's been harm or a threat of harm, and you can get a public health remedy affected. It's not money. It's not $2.4 billion check that's going to the state coffers. It's actually getting these defendants to put abatement workers in there who are going to minimize the risk of harm to children. Very different than a product liability case where the remedy is limited to damages. You have to have suffered an injury, and then a jury has to monetize that. And the third I mentioned under public nuisance, which is it allows you to prevent future harm. You don't have to wait until kids get poisoned, which is completely counterintuitive when you think about it. Why should we send our children out there to get poisoned to fix the problem when we could fix the problem before they get poisoned? Product liability doesn't allow for that. You have to be poisoned first for anything to happen. The elements of the two claims are very different. Under public nuisance, you have to prove that there's a condition that harms or threatens to harm the public. That's a very difficult standard to meet. It's not enough that a single child was poisoned or 5 children were poisoned. You have to prove a much greater threat or actual harm to the public. And then you have to prove that the defendants in a public nuisance suit engaged in conduct that created, maintained, or contributed to that public nuisance, that they did something to result in the particular public nuisance. You can see from this it's very, very different from the traditional product liability elements. It's against this legal backdrop that the Rhode Island case was tried, and it started on November 1st of 2005, and there was a jury verdict on February 22nd of 2006. It was the longest civil trial in Rhode Island history. And there were 3 questions for the jury on their jury questionnaire. And first was whether the presence of lead pigment throughout the state was a public nuisance. Second, if a public nuisance did exist, were the defendants liable for that nuisance? And even if these defendants were liable, is abatement the appropriate remedy? Do we want to go in there and do we want to abate this before more children are poisoned. Here's what that jury unanimously said. They said that a public nuisance exists because of the collective presence of lead in Rhode Island. That it's not about 5 homes or 93 homes, it's about the fact that this is everywhere. And any particular day, a home that has never produced a poisoned child before, that we've no idea has lead paint in it, can end up, because of someone doing renovation work or even doing something as simple as opening and closing their windows repeatedly, can produce a poisoned child. Second, the jury found that 3 of the defendants, Sherwin-Williams, Millennium Holdings, and NL Industries, are liable for the nuisance. That was after listening to months of evidence about what these companies did and didn't do to create that public nuisance. And finally, that the 3 defendants should be responsible for abating a nuisance. There are so many legal issues that have come out of not only the Rhode Island case, but the other public nuisance cases, many of which are fascinating, but the one I'm going to focus on is what I started with, which is the distinction between the product liability and the public nuisance cases. And there's been significant precedent that's come out of these lead cases that applies not only to the lead cases, but also to other public nuisance cases that could be brought elsewhere. State of Rhode Island. After the jury verdict, there was extensive briefing, 200-plus page briefs that were filed, motions for a new trial, motions to overturn the verdict, motions for a directed verdict, and the judge, it was about a year between the verdict and when he wrote a 197-page decision that addressed a whole host of public nuisance cases. But one of them that's been particularly interesting and has become the source of a lot of discussion is whether there's a requirement for product identification. In other words, do you have to prove that it was Sherwin-Williams paint, or Glidden's paint, or NL's paint that was in a home or particular homes before you can hold them responsible under public nuisance? And of course, product identification is something that is required in most product liability cases. There are a few that have a risk contribution or market share theory, but that's kind of the hallmark of a product liability case. And the manufacturer said, well, look, if you sued us in a product liability case, you had to prove it was our product. You have to do that in public nuisance as well. And the trial court in Rhode Island said, no, you don't have to do that. And he stressed, as he did numerous times, this is not a product liability case. You can't look at it as a product liability case. And nowhere in the law of public nuisance is there a requirement of product identification. It doesn't exist. You can't incorporate those product liability concepts wholesale into public nuisance cases. Santa Clara versus Atlantic Richfield Company. This is one of the cases that Mr. Spellman referred to, and that was a case that the California 6th District California Appellate Court, in a lengthy decision, found that public nuisance is an applicable theory in lead pigment cases. The California Supreme Court rejected the petition for cert on this case. And the California decision is a great decision because it very succinctly, in certain sections, deals with what the allegations are and what the legal theories are. And here's what they said about the allegations. So here, Santa Clara, San Francisco, and Oakland, those are the plaintiffs, allege that the defendants assisted in the creation of this nuisance by concealing the dangers of lead, mounting a campaign against regulation of lead, and promoting lead paint for interior use, even though defendants had known for nearly a century that such use of lead paint was hazardous to human beings. Defendants engaged in a massive campaign to promote the use of lead on the interiors and exteriors of private residences and public and private buildings, and for use on furniture and toys. And this is the key on the causation. Had defendants not done so, lead paint would not have been incorporated into the interiors of such a large number of buildings and would not have created the enormous public health hazard that now exists. And what Santa Clara Court recognized, like the Milwaukee Appellate Court, like the Rhode Island Trial Court, is If these defendants hadn't made the choices that they did, be they 50 or 60 or 70 years ago, we would not be in the position that we're in today, where children's lives and health are being compromised. The California court went on to recognize the distinction between product liability cases and public nuisance cases, and really crystallized this issue. And they stressed that a representative public nuisance cause of action seeking abatement of a hazard created by affirmative and knowing promotion of a product for hazardous use is not essentially a product liability action in the guise of nuisance, a nuisance action, doesn't threaten to permit public nuisance to become a monster that would devour in one gulp the entire law of tort. They said, this isn't the sky is falling, the sky is falling. If you let this go forward, everyone's going to come in public nuisance cases, because they recognize you need a unique plaintiff and you need to have a very unique remedy. And it goes on to say, because this type of nuisance action does not seek damages, but rather abatement, a plaintiff may obtain relief before the hazard causes any physical injury or physical damage to property. A public nuisance cause of action is not premised on a defect in a product or a failure to warn, but on affirmative conduct that assisted in the creation of a hazardous condition. This isn't a crazy theory that has been dreamt up by some wacky lawyers in their offices and then sold to the public. This is a theory that courts across this country are recognizing as a viable way of protecting the public health from a known danger. California court went on and noted the contrast with the product liability action. I'm not going to read through all of this, but it notes that product liability action is brought by an individual injured plaintiff versus the government official. Recognize that a product liability doesn't provide an avenue for protecting the public from future harm. And also the availability of the abatement remedy. And they say, for these reasons, we are convinced that the public nuisance cause of action in the third amended complaint is not a disguised version of plaintiff's product liability causes of action. I think this slide sums up what public nuisance is and what public nuisance is not. We heard a little bit about landlords and blame being cast on landlords. And we heard from Mr. Spellman about parents, and we heard about what the state is or isn't doing. The entire gist of these public nuisance actions isn't to say that the lead pigment companies alone are responsible or bear all of the responsibility for what has happened here. But what it does recognize is that the state and taxpayers, parents and homeowners, have been the ones who've been sitting at the table since 1991. So when you hear about these drops in the number of children who've been lead poisoned and the public health success story, and the fact that Rhode Island is reaching 5% or less poisoned, it's not because of what these defendants have done. It's because of what homeowners and parents and landlords and state and taxpayers have done. And what the jury found in Rhode Island is that this last piece of the pie, the defendants, since they will not come to the table voluntarily to help solve this problem, through public nuisance causes of action, can be held accountable and can be made to share in the responsibility and to become part of the solution to the problem instead of part of the problem itself. Thank you.
Thank you very much, Fidelma. Now we have Mike Nyland from Minneapolis.